What we are doing today is more than signing an agreement. It is a revolution. Yesterday, a dream. Today, a commitment.
The whole purpose of what had become known as the Oslo Accords was to bring about peaceful coexistence between the State of Israel and the people known as the Palestinians. The two main aims were to give the Palestinians self-determination in return for the end of the conflict between the two parties. Central to the Oslo Accords was the complete renunciation of terrorism by the PLO. In 2000, the parties met to negotiate the long-awaited final status agreement. In the 5 years following the Camp David summit in the summer of 2000, Palestinian terrorists murdered 1,137 Israelis in what became known as the Second Intifada. Nearly 80% of them were civilians.
To have people being blown up, of families, children, in cafes, in buses, and it's in Tel Aviv, in Haifa, in Beersheba, not in the West Bank, not in Gaza. Supposedly nothing controversial about these areas, but this is where families were being targeted and were being killed.
Most of the attacks were launched from within the so-called West Bank. Israel had no choice but to defend its civilian population. One of the measures employed was the construction of a security barrier, part of which you can see here. This security barrier reduced terrorist attacks by at least 90%. The only reason Israel built this barrier was to protect Jewish lives, period. The Palestinian leadership, who dubbed it as the apartheid wall, sought to have it outlawed by the United Nations and the International Court of Justice in The Hague.
In 2004, the International Court of Justice in The Hague issued its opinion on Israeli anti-terrorism measures, and in particular the structure that it built to obstruct traffic between the West Bank and the heartland of Israel. In order to understand it, you have to understand what it is legally.
The International Court of Justice is not a world court with power to determine legal issues anywhere around the world. They have the power to determine certain sets of legal issues, of which this was not one. On others, they can simply give their advice.
Now, what it was entitled was an advisory opinion, and that's what it is. It was giving us the opinion of the 15 appointed judges to the International Court of Justice. It's not legally binding. The charter of the ICJ tells us what the legal value is of an advisory opinion, and it is that it's legal advice. It may be followed or not followed.
The Arabs initiated in the United Nations condemnation of Israel for building what they called an apartheid wall, claiming that this took land from Palestinian landowners. The truth is, it's not true. The land used was used on the basis of temporary orders for use of the land in return for compensation, and once there's no need, then the land is returned. And the Israeli Supreme Court was highly involved in all issues of landowners making claims against the fact that the fence was on their land, and in many cases the court changed or redirected the direction of the fence.
The judges that are appointed to the court are appointed by the United Nations, and they're appointed according to rules that the United Nations has adopted for itself for regional balance. And these rules more or less preclude the possibility of any Israeli judge ever serving on the court. It's the only state which has no possibility of ever having a judge on the court. Israel
Questioned the legality of the whole process and questioned the jurisdiction of the court because, for instance, the Egyptian ambassador who initiated this whole resolution in the General Assembly was ultimately appointed a judge on the International Court of Justice, and he was one of the judges. And so he said, this is absurd.
The General Assembly's advisory request was that the court tell the General Assembly what to do about a wall that Israel was constructing that the General Assembly had already pronounced to be illegal. And that's the way the court analyzed it. Now, there's another interesting facet of the opinion. It made a pronouncement, for example, that Israel lacks the right to engage in self-defense when attacked by terrorists stemming from territory that Israel controls.
By the time the International Court of Justice convened in 2004 to consider the security barrier, Palestinian terrorists had murdered over 1,000 Israelis in the previous 3.5 years. Massive demonstrations took place outside the Palace of Peace, which houses the International Court of Justice in The Hague. On the one hand, there were protesters who condemned Israel's so-called apartheid wall. They presumably approved of the ongoing slaughter of Jews. On the other hand, thousands of people came out, many displaying a photograph of a murdered Israeli Jew and calling for justice to be done, and for the right of Israel to defend her citizens. To make the point, a Dutch group, Christians for Israel, brought a bombed-out bus over from Jerusalem and parked it across the road from the court. 20 people were killed in this particular terrorist atrocity. 7 of them were infants and children. Nevertheless, the court's opinion came down against Israel.
Because it said self-defense can only, according to Article 51 of the UN Charter, can only be directed against a state that attacks you. If it's not a state, if it's just Palestinians from occupied territories, then you can't invoke the right of self-defense.
It's not consonant with self-defense law as we understand it, and it simply defies common sense to say that Palestinian terrorist groups may attack Israeli civilians with impunity.
The status of the territory as occupied was presumed within the General Assembly's submission, within the question asked, and thus the question of the actual status was never examined.
The International Court of Justice also determined the legality of the settlements, and it did so by its misinterpretation of its own precedents. It declares that the mandates were set up to protect the rights of the indigenous population and the self-determination of the indigenous population. And from there, it leads to a discussion of the rights of the Palestine indigenous population, maybe to set up a state for themselves.
The precedent that the International Court of Justice chose to determine the illegality of the settlements, in other words, Jewish domicile in their historic heartlands of Judea and Samaria, otherwise known as the West Bank, was the mandate for Southwest Africa, which was for the self-determination of the indigenous population there. However, the mandate for Palestine was set up for an entirely different purpose and ignored.
The court misdirected itself.
The mandate of Palestine was quite specific about who was the beneficiary of this right of self-determination. The preamble to the mandate tells us that the mandate was created in order to reconstitute the Jewish homeland on its ancient land.
It's worth noting here that the mandate does not name any other ethnic group or any other peoples than the Jewish people as far as obtaining through the mandate political authority over this territory.
If you read through the mandate, you'll see there are a number of provisions that were designed to guarantee that. The mandatory authorities, the British, were supposed to cooperate with the Jewish agency in running the mandate. They were supposed to encourage and facilitate the acquisition of citizenship by Jews, immigration by Jews, close settlement of Jews on the land. So there are all these provisions that show us that it was a mandate designed to guarantee the self-determination of the Jewish people. It was applied in favor of the Arabs in the area known as Mesopotamia, in the area known as Syria and Lebanon. But in Palestine, the political rights of self-determination was exercised in favor of the Jewish people.
The Jewish settlements and the claim for Israel to exercise jurisdiction over the West Bank, I think, is legally supported, certainly by Article 80 of the UN Charter.
There really is no internationally legally binding source that they pointed to, and no analysis they gave us for determining that settlements are illegal under international law. They simply brought out the General Assembly opinion and treated it as if it were the law.
The International Court of Justice's conclusion was criticised by the dissenting judge, Judge Bergenthal, and he noted that the ICJ's opinion failed to address any facts or evidence. It's often said that the facts lie at the foundation of the law, and the law arises from the facts, ex facto jus oritur. And the court did not consider at all the wave of suicide bombings from infiltrating Palestinian terrorists, which Israel had suffered since September 2000. Now, the difficulty the court had in making a proper assessment of matters in the case of Israel's security barrier is that the court was presented with a raft of false information.
So how has this advisory opinion from the International Court of Justice in The Hague impacted Israel? Let me first say that Israel made the decision not to appear before the court to offer any defense for its course of action. This is because Israel questioned the jurisdiction of the court to pass judgment on this issue, as well as questioning the composition of the court itself and the parameters given by the UN General Assembly. From a public relations point of view, the International Court's opinion has not helped Israel's defense at all, even though its findings are unenforceable and carry no legal weight. From a legal perspective, the court's findings are deeply flawed. In the next episode of Whose Land, we look at the controversy over the Jewish communities in Judea and Samaria, often referred to as illegally occupied Palestinian territory. Is this terminology really based on international law, or is it simply anti-Israel propaganda?